Good afternoon and welcome to the fourth installment of McDermott, Will & Emery's Healthcare Enforcement Quarterly Roundup. Today's program also serves as a wrap-up of our first year of the quarterly roundup being in publication. My name is Amandeep Sidhu, and I'm a partner in the Washington, D.C. office of McDermott. The quarterly roundup is a collaborative effort across our health litigation platform that examines key enforcement trends that we are seeing in the healthcare industry. Our goal with the quarterly roundup is to help our clients look around the corner to understand how these trends may ultimately impact companies and organizations across the healthcare landscape. In particular, the quarterly roundup is focused on the False Claims Act and how these trends may impact FCA enforcement and litigation. To that end, we recommend that you follow our FCA update blog, where our team is regularly tracking key cases and regulatory developments that could impact the FCA landscape. For those of you that are joining us for the first time on the line today, thank you for making time to be with us. For those that are returning after joining earlier quarterly roundup webinars, we really appreciate your support over the last year. From a housekeeping standpoint, we'd encourage everyone to take time to complete the survey at the conclusion of the webinar, and you'll receive a link in an email after the conclusion of the program. If you require CLE, you will have the opportunity to select the state in which you are requesting credit. And if you require CLE credit in New York State, please listen for a secret code that we will provide towards the end of the webinar. You'll need this to receive credit. We have an excellent panel for you today covering a wide variety of topics, some of which we've covered throughout 2018 and some of which are new and on the horizon for 2019. I'm going to introduce each of our panelists and then hand it off to our speakers as we make our way through the program. First, you'll hear from Rebecca Martin regarding DOJ's fiscal year 2018 FCA statistics, and then receive an update on recent updates that have taken place with regard to the Yates Memorandum on guidance regarding individual accountability. Becky is a partner in McDermott's New York office and a member of our litigation practice group. She has broad experience in investigations, litigation, and settlements involving the False Claims Act and a kickback statute and other healthcare and financial fraud matters. Prior to joining McDermott, Becky was a 15-year veteran of the U.S. Attorney's Office in the Southern District of New York, serving most recently as the co-chief of the Civil Fraud Unit and Healthcare Fraud Coordinator for SDNY. She also serves as an editor of our FCA Update blog. Next, you'll hear from Reed Stevens on recent developments regarding the Granston Memo. Reed is a partner in our Washington, D.C. office and is the partner in charge of the Health Industry Advisory Practice Group in D.C. Reed represents clients in the life sciences industry, including pharmaceutical and biotech manufacturers, wholesalers, and individuals, as well as healthcare systems and non-healthcare related companies in other global industries, including defense and the financial services and banking sectors. He also represents clients in matters involving state and federal government law enforcement, voluntary disclosures, and congressional investigations. Third, you'll hear from Laura McLean. Laura sits in our Boston office, where she is the partner in charge of the litigation practice group in Boston and is the co-chair of our healthcare litigation team. Laura regularly represents healthcare companies and individuals in government investigations and qui tam litigation based on the False Claims Act. She's also a founding editor of the FCA Update blog, so she has her finger on the pulse of some of the trends as they are emerging in the healthcare enforcement landscape. Laura will discuss the continued evolution of case law following the Supreme Court's landmark decision in the Escobar case. Finally, I will round up the program covering continued enforcement efforts on the state and federal level regarding the pain management industry. As I mentioned on the front end, I'm a partner in our Washington, D.C. office. I'm a member of our litigation practice group and a part of our healthcare litigation team. My focus in my practice is on compliance and regulatory counseling, state and federal investigations, and related litigation. with a particular focus on FCA-related matters. After we complete the program and we get through each of those topics, there will be an opportunity for questions and answers. The web platform does have the ability for you to submit questions throughout the program, and we will review those and add those to the queue at the tail end of the program. So with those housekeeping items out of the way, I'm going to pass the mic to Becky Martin in our New York office.
All right, thank you very much, Aman, and hello to everyone out there, and thanks for tuning in. I will try to make this as interesting and as possible. So I'm going to talk about the False Claims Act statistics that DOJ issued, and which it issues every year. And I think for those who follow this area, you know that the last half dozen year of these statistics coming out has actually, believe it or not, been a roller coaster. And just focusing on the False Claims Act, the civil fraud recoveries from DOJ have bounced around annually. And just to give you kind of a bigger picture, just taking a look starting in 2011, FCA recoveries were $3 billion. They bounced up the next year in 2012 to $5 billion. Next year down again to $3 billion, then in 2014 up to $6 billion. 2015 back down to $3 billion and then up to $5 billion in 2016. So 2017, the recovery went down to $3.5 billion, and which was kind of just part of the pattern. Was it significant or wasn't it? And if the pattern was going to hold, we would have expected this year for recoveries to be up to about $5 billion. Not so. So the big headline is that the recoveries for FCA have dropped further in 2018. In fact, they dropped to $2.8 billion, which is the lowest they've been since 2009. And this really comports with a lot of water cooler discussion about slowing enforcement, some changing priorities. A lot of tea leaves are being read, but I think we now actually have the bottom line dollar number that shows us a bit of what's going on. But the biggest beneficiary of these changes is the financial industry. For instance, in 2014, that was DOJ's biggest year for False Claims Act recoveries, and the total, as I mentioned earlier, was $6.1 billion. Over half of that, 3.1, was related to mortgage and housing crisis recoveries. But those recoveries really appear to have bottomed out. So for the healthcare industry, though, the numbers really paint a different picture. The $2.8 billion that was recovered in 2018, of that, 2.5 was healthcare related. So that's 89% of the False Claims Act recoveries came directly from the healthcare industry. And it really did cover the industry. Nobody was spared. Drug and device manufacturers, managed care, hospitals, pharmacies, labs, hospice providers, individual physicians. They were all part of the DOJ collections. But these healthcare numbers in 2018 are still, very interesting, are still just a snapshot. And I know people have tuned in today to sort of, get a little insight on what the actual trends might be. So why don't we just take a moment and push away all the non-healthcare numbers. And what we are actually seeing is that in terms of DOJ recoveries, relatively little has changed since 2010. The healthcare recoveries in 2010 were $2.5 billion. And since then, the number has bounced around from 2.1 to about $3 billion. But the median recovery for all of those years, and it's the strong median, is $2.5 billion. And that is exactly where we are this year. So 2018 actually looks an awful lot like 2010 in terms of DOJ recoveries. But there are other trends that are worth noting, and not everything looks like it did in 2010. It's important to look at the volume of cases, and let me switch to the next slide. And these numbers tell you something on this slide, but it's really important to look at the volume every year because that gives you a little glimpse into the future. It tells you what may be coming in terms of the volume of DOJ recoveries. So the good news is the overall volume of new cases has declined. In 2018, there were 767 new cases, and that compares to 799 in 2017. And for healthcare, and so again, that was overall, not just healthcare, but the whole landscape out there. And for healthcare cases, there's a similar downward trend. 2018 saw 506 new cases versus 550 from the year before, and 573 from the year before that, which was 2016. So clearly good news. Because there's always a downside, or another way to look at things, you do need to consider that there was actually a shift in the case mix at DOJ. So while the trend line is down, healthcare does constitute a larger percentage of the overall False Claims Act cases filed. In 2010, healthcare was 59% of the total False Claims Act cases that were filed, and that's crept upwards for the last 3 years. And now, healthcare represents 66 to 67% of the total False Claims Act cases. So what does that mean? And it means that relators may be more incentivized to bring healthcare cases as opposed to other types of cases, sort of classic government procurement, defense cases. Rest assured, relators are always incentivized, but it is worth noting that of the recoveries for 2018, so again, it was $2.5 billion in total. Of that, 1.9 came from cases filed by relators, and they received $266 million. But it seems pretty arguable that there's more of an incentive for relators to focus on healthcare, because while 66% of the overall healthcare, 66% of False Claims Act cases are healthcare, but healthcare represents 89% of recoveries. So to use a loaded term, it looks like DOJ's return on investment might be a bit higher in the healthcare space at this time than it has been in other years. And relators pay very close attention to that kind of thing. So, don't expect relators' attention to go far away from healthcare at this point. In the press release where DOJ issued its year-end statistics, the government also noted a number of priority areas. First, DOJ noted that a number of its cases reflected its ongoing commitment to vigorous enforcement of the anti-kickback statute. If that sentence sounds familiar, there's a reason for that, because this has long been a favorite sandbox for DOJ, and DOJ does not appear to be expecting a change in that focus. Another priority area for DOJ is its continued focus on individual accountability in its enforcement activities, and later in the webinar we will discuss this in a bit more detail. And finally, there is a third area that's garnered a lot of attention last year, and we expect to continue to do so in 2019. And this is the so-called Granston Memo. And this memo relates to DOJ's newly invigorated use of its power to dismiss QTAM False Claims Act cases that have been filed by relators and that have been declined by DOJ. My partner, as Aman mentioned earlier, my partner Reed Stevens, not the law firm, but Reed Stevens, will discuss the Granston Memo in more detail on this webinar. But it's really interesting to note that the DOJ movement to dismiss declined QTAM cases is actually paired with a downward trend in terms of the amount of relator rewards, and not in terms of the percentage that relators get. And you can see a real downward trend in the percentage that relators have been getting over time from DOJ. So I think this may be a good time to transition to the next section where Reed will discuss the memo, unless anyone has any questions.
Thanks, Becky. So for those of you who have not been following the Granston Memo developments, I'll just quickly give you an overview. The Granston Memorandum is entitled after the director of the fraud section, Michael Granston, and it was issued about a year or so ago and intended to provide some guidance on the DOJ's long-standing authority under 31 U.S.C. Section 3730 C2 capital A of the False Claims Act to dismiss QTAM FCA lawsuits over the objection of relators. Now, the detailed guidance for these circumstances is really meant to cover non-intervened cases. Those are the cases that the government has investigated and already determined that it does not have an interest in taking on the litigation itself and pursuing it against the defendant. But the C2A authority is intended to actually take the drastic remedy of disposing of cases with finality so that the relator cannot investigate and litigate on his or her own. So the authority has been characterized as an important tool to advance the government's interest, preserve limited resources, and avoid adverse precedent. But in reality, in the past, it's been very infrequently used. The discretionary authority has typically been kept on the shelf, and cases have been allowed to play themselves out. And if the government felt that there was an interest, it had an interest in a result or a particular legal issue or a motion, it would participate in the litigation under its normal discretionary authority to participate under the statute. Now, the Granston Memorandum's publication has prompted speculation as to whether there's a new era of activist dismissals that are going to be coming. In previous years, defendants would try to initiate that discussion with the government and see whether they could get any traction. So what's new? So in December of 2018, the United States brought motions to dismiss in nearly a dozen declined qui tam cases brought by relators apparently acting under an organizational umbrella of an entity called the National Healthcare Analysis Group. And the cases were brought in various federal courts around the country in various circuits. All these cases were filed against biopharma manufacturers and the patient access service vendors that provide physician with patient access services that are typically paid for at the expense of the manufacturers. The United States pejoratively characterized the relators as a shell company of whistleblowers filing boilerplate allegations. And it was interesting that the government made a point of highlighting the corporate form of the relators, and it seemed like it was something, an important theme that ran through motions to dismiss. So what were the basis for the motion to dismiss? So the premise of this C2A motion to dismiss is not really a merit-based argument. It's typically one that's based on a particular government policy or preference. There are a couple of seminal cases out there that have set forth two different standards for judicial review of the government's motion to dismiss a declined False Claims Act qui tam. And the United States moved to dismiss in these cases using an either-or approach to the two standards that have been applied by the courts, the way the United States power used the C2A motion. Now, the first standard for dismissal is, of course, the broadest, and the United States led with its unfettered right to dismiss as set forth in the Swift versus United States case in the D.C. Circuit several years ago, which was very straightforward on behalf of the government, setting forth a highly circumscribed power of judicial review. Basically, the court took the position that the United States and the Department of Justice could do whatever it felt best. Now, there's another case out of the Ninth Circuit that actually preceded Swift that had a different standard. In the United States ex rel Sequoia Orange versus Baird Nice Packing Corporation case, the U.S. has to show a rational relationship between the motion to dismiss and a valid government purpose for its motion to dismiss. At that point, if the government has achieved that, the burden shifts to the relator to show that the United States motion is either fraudulent, arbitrary, and capricious, or illegal. Now, that's obviously a standard that provides a little bit more opportunity for a relator to challenge the United States bid to get rid of their case. Here, the U.S. is asserting the bid to dismiss related to valid governmental purposes of preserving scarce governmental resources and protecting important policy prerogatives of the federal government's health care programs. So what does that really boil down to? If you look at the policy justifications for the U.S. motion to dismiss, which really are the meat of these various motions that it filed, the United States takes kind of an interesting position. It's not really relying just on the deference argument. It's also arguing the merits in a certain sense, that the cases are just bad, frivolous, meritless cases. Specifically, the U.S. asserted the legal and factual deficiency under the anti-kickback statute for the various allegations of fraud that are in the cases. Specifically, that the fraud allegations about patient support services that are offered to physicians, even if true, cannot constitute a violation of the AKS. That's a very strong affirmative statement to be made on a motion to dismiss, and not something that most litigators would expect to see, because it really assumes facts and evidence. So the government is taking advantage of the fact that the primary premise of the motion is that its position should be given the utmost deference regardless of its reasons. But it certainly piles on in these briefs additional reasons. So the United States points out that it supports, generally, patient access programs that are intended to make it easier for patients to use drugs that are prescribed for them and to afford drugs that are prescribed for them, to use them properly and compliantly based on their physician's orders. And the United States, in its motions, points out it spends vast sums on the drugs at issue and has a strong policy interest in ensuring that patients have access to information and product support from the manufacturers. Next, it points out that the relator's allegations were boilerplate and that the cases represent an indiscriminate advance of claims that would weaken common industry practices that are beneficial and appropriate to federal health care programs and their beneficiaries. So another strong statement on behalf of industry practices by the United States in its motion. Last, but also very important, the burden in time and cost from third-party discovery. So the United States is looking at all these cases that were brought by this sort of consortium of relators and is anticipating that it's going to have to face a lot of third-party discovery. The FDA, HHS, and the other federal agencies that are implicated by these programs are going to be facing TUI requests for discovery, possibly depositions, interrogatories, document requests, and the government's not relishing the thought of having to deal with all of that attorney time being allocated to these cases. So how did the relators respond to this? So there was some question as to whether or not the relators would just throw in the towel and move on to some other venture. But about a week ago, the relators did file opposition briefs in the remaining cases that are still out there. And interestingly, the relators did not really focus on the deference issue so much as arguing that the merits should be litigated at this stage, sort of mirroring the United States approach of trying to show that there is nothing to the allegations and they were legally and factually deficient. Relator takes the opposite position that the unfettered discretion of the SWIFT standard doesn't apply and that the Sequoia standard should be used here, which gives them, in their view, more of a chance to argue and establish that the United States does not have a rational basis for its motion to dismiss and that there is not a valid governmental purpose being served. Relator also defended the legitimacy of their corporate formation and their investigative practices and their status as original sources, even though they did not necessarily have insider access to information in every case. So the factual assertions on the merits were also made in the opposition briefs that, in fact, violations of the anti-kickback statute had occurred. again, not really the kind of assertions you'd expect in response to a motion to dismiss, but this is an unusual situation. A relator, of course, also asked for an evidentiary hearing. So it's going to be very interesting to see whether the courts are as willing to entertain these merit-based debates between the United States and the relator on the motion to dismiss. Again, most litigators are going to be aware that this isn't the type of argument that you have at this stage. It's whether or not a relator has stated a claim that upon which relief can be granted, not whether or not complaint actually sets forth evidence of fraud or other improper conduct being committed. But that's where we are. And we're in this phase right now where we're waiting to see whether the courts are going to grant hearings, whether there'll be different results in different circuits and different district courts. And it's going to be a very interesting test of whether the United States approach here is going to get traction. Now, the last thing that we want to note about this is Congress is not sitting by idly while this is all taking place. So the Granston memo was discussed during the confirmation hearing for Attorney General nominee William Barr. Senator Grassley of Iowa, who is now the chairman of the Senate Finance Committee, formerly the chair of the Senate Judiciary Committee, still retains his long-standing interest in the False Claims Act and how it is prosecuted and managed by the Department of Justice. And in the hearing, he raised concerns about whether this assertion of a valid government purpose centering on preserving government resources is an appropriate one that can be managed in a way that does not undercut the purposes of the False Claims Act. His quote is, "Just think of all the mischief those three words, preserving government resources, can bring." So while he had Mr. Barr on the stand, he did extract from him a promise that, if confirmed, would he commit to ensuring that the department doesn't unnecessarily dismiss False Claims Act cases, to which Mr. Barr said that he would enforce the law in good faith. A laudatory statement, and I'm sure one that can be taken on face value. But the real issue is going to be whether or not the courts are going to go along with the unfettered discretionary dismissal approach of SWIFT, or whether or not they're going to retain some standards for review of government's decision-making. With that, we'll move on to our discussion about the Yates Memorandum by our colleague. Back to Becky Martin.
All right, thank you. I wanted to, chime in again, and this time on the Yates memo. So in previous webinars and in other quarterly roundups that I hope some of you out there listening have seen, we have discussed the Yates memo. And this was originally issued in September 2015 by Deputy Attorney General Sally Yates, and she laid out a revised, at that time, DOJ policy on individual accountability in the context of corporate investigations and prosecutions. It engendered an awful lot of discussion and memo writing and panel discussion when it first came out in 2015. And then with the change in administration, there was another round of discussion and prognostication, and the fate of the memo has been continually discussed by the defense bar. And in the fall of 2017, so a little over a year ago, DOJ announced that the memo was under active reconsideration, and so that was the first official statement that Yates was going to be revisited, and even more discussion ensued at that point. So on November 29th of 2018, so not quite 2 months ago, we were all put out of our misery, and the Deputy Attorney General, Rod Rosenstein, announced much-awaited changes to the DOJ policy on individual accountability. So the short answer is that the Yates memo still lives it doesn't really go by that name, in DOJ's way of speaking anymore, but we all know where it started. And it does still live on, but it is really scaled back in the criminal context, and even more so in the civil context, and specifically in the False Claims Act area. So these changes, on the surface at least, do not actually seem to signal a fundamental shift away from individual accountability. Instead, the changes seem designed to lessen inefficiencies that were created by the original memo. In addition, the changes in the civil fraud area, the focus continues to stay on senior management. So as a starting point, Dag Rosenstein emphasized that under the revised policy, pursuing individuals who are, quote, responsible for wrongdoing will continue to be a top priority in every corporate investigation. So they're not backing away from it as a core principle. In the criminal context, the revised DOJ policy makes clear that, quote, and I'm quoting here, absent extraordinary circumstances, a corporate resolution should not protect individuals from criminal liability. So the revised policy will lessen the level of disclosure previously required by the Yates memo in criminal matters. And to be more specific about that, under the original memo, DOJ expected companies to disclose, quote, all facts relating to the individuals involved in the wrongdoing, no matter where those individuals fall in the corporate hierarchy, in order to obtain cooperation credit in criminal matters. So this is obviously a huge challenge to a company and to a practitioner, especially when the relevant conduct covers many years and could involve routine operations of the company and could involve scores or sometimes hundreds of employees. So that difficulty and the impracticality of actually complying with that is something that the DAG really actually, acknowledged pretty directly in his speech. And now, under the revised DOJ policy, companies under criminal investigation need, and I quote, only identify individuals who were, quote, substantially involved in the alleged conduct. So, from a big picture perspective, this should tighten the focus of defense and government discussions considerably. And overall, the revised policy should lift part of the burden of investigations. But the rubber will hit the road when counsel has to decide what, quote, substantially involved actually means. And in fact, the DAG noted in his speech last year that, and again, I'm quoting, I just don't want anyone to think that I'm characterizing, because these words are very important. He said that if we find that a company is not operating in good faith to identify individuals who are substantially involved in or responsible for wrongdoing, we will not award any cooperation credit. So a practice point here is to be as transparent as possible with DOJ counsel about the process that you're using, and to keep channels open regarding how you're identifying individuals. It's always good to keep those heated hallway discussions with AUSAs to a minimum, and you can well imagine that they will happen in this case, or with these issues of what substantially involved actually means. So now I wanted to shift gears a little bit to civil cases. And as the DAG noted, civil cases are different, and in fact, False Claims Act cases are different. What the DAG emphasized is that principles of individual accountability continue to apply in the civil context, but nonetheless, the civil cases really are different. And they are different in that the primary focus of civil fraud investigations has always been the money. He acknowledged the inefficiencies and the delays that were caused by the Yates requirement to disclose all facts in connection with all individuals involved in any alleged wrongdoing. Again, it was exactly the same problem that we saw in the criminal context, where you've got, I think people are probably on this call familiar, the False Claims Act statute of limitations can go back 6 years, 10 years, and sometimes if you have a key TIM that's been under file for a while, you can be looking at 13 years or more of potential exposure. And at times, the conduct at issue is considered a perfectly appropriate course of conduct, so has really gone on a long time, and you are really talking about a huge number of people who could potentially be involved. So while the DAG actually acknowledged these issues, the Yates still does have force in the civil realm, and it really has force with respect to civil management. In particular, and I'm sorry, I think I kind of skipped over a point here, which is that what the DAG noted for minimum credit, what a company needs to disclose is that you have to identify all wrongdoing by senior officials, including members of senior management or the board of directors. So it's a very appointed and pretty unusual reference to senior management by DOJ. Now, at the other end of the spectrum, the revised civil policy provides for maximum credit, but only when a company identifies every individual person who is substantially involved in or responsible for the misconduct. So 2 points really jump out. Again, the minimum disclosure required for any credit does require all wrongdoing related to senior management. And I think there are just two nuances here that are worth focusing on. It says all wrongdoing, and so it doesn't say substantial involvement. It seems to be a different standard there. And also, again, it really relates just to senior management. So DOJ is essentially saying, you don't need to tell us about everyone from middle management on down, but we do, if you want to get any credit, we do need to hear about all wrongdoing committed by anyone in senior management. The second point that really jumps out is that for maximum credit, civil tracks the criminal requirement that everyone substantially involved in the misconduct has to be identified. So in either the minimum or maximum credit context, much is going to hinge on the definition of wrongdoing and misconduct, as well as substantially involved. And again, we know that a company will legitimately and in complete good faith view certain conduct as appropriate, but the 30-year-old AUSA is going to beg to differ. So communication here on the definitions that you're using, can really be key to having a productive dialogue with an AUSA. There are other gray zones in between minimum and maximum credit boundaries. There is a zone where company can get some credit in exchange for meaningful assistance. DOJ has given some gloss on what meaningful assistance may mean. So there is some guidance there, but it is still pretty fuzzy at this point. There are other points made in the memo that raise questions. For instance, in 2015, the Yates memo eliminated DOJ's historical practice of granting releases to employees, officers, directors in corporate False Claims Act settlements. But now, under the revised policy, civil fraud attorneys are permitted to negotiate civil releases who, quote, do not warrant additional investigation in corporate civil settlements. Whether this really means a reversion to the prior broad releases or some other new norm is a key factor that we are going to be monitoring. But the biggest area that still needs clarification is really what cooperation credit means in False Claims Act cases in a dollars and cents kind of way. Cooperation in criminal cases is pretty well understood, but it is simply not so in civil cases. So what credit, what does that mean? What will a company get in terms of how damages are calculated? What model will DOJ use? How will multipliers be used? Will it be 2.5, will it be 2, will it be 1.5, depending on the level of cooperation? How will False Claims Act penalties be used? How will they be calculated? None of this is mapped out at this point. And we'll be closely monitoring this as well, as I'm sure everyone on this call will be. Lots of unanswered questions still, but I think this is probably now a good time to hand the mic over to my partner, Laura, on the developments on the Escobar front.
Thanks, Becky. Hey, everybody. Thanks for joining us today. And I'm going to jump right into a subject that is near and dear to my heart, the Escobar case and the court decisions that have come down since June 2016 when the Supreme Court took up or issued its decision in Escobar, and that's a case that we actually took to the Supreme Court. So we have been following its progeny very closely, as you might imagine. And so I want to talk about some of the recent developments, although anyone who's familiar with the decision knows that the sort of in the past, couple of years since it came down, there's been just a ton of case law interpreting the decision and, frankly, disagreements among different courts on various issues. So we'll talk about some of those today. So the one thing I wanted to focus on is this two-part test in Escobar. When people hear about Escobar, they think of it as, okay, that's the case that held that implied certification is a basis or a theory of FCA liability that is viable, but there are some guardrails around when it is and when it's not. And one of those guardrails is materiality. In other words, the violation of law at issue that underlies the claim has to be one that is material to the payment decision of whoever the government payer is. If it's not material, then it's not a false claim. So that was sort of like the big headline from Escobar, which is this new reinvigorated materiality standard, and much has been written and argued about what that means. But what Escobar actually said was two things. It said that implied certification can be a basis for liability where two conditions are satisfied. First is that the claim does not merely request payment, but also make specific representations about the goods or services provided. And second, the failure to disclose noncompliance made those representations misleading. And the number two, as you can see on the slide, is the materiality piece. In other words, that's where materiality kind of comes from the decision. And then the court went on to describe a bit more about what that means. But point one was sort of, for a while, the overlooked part of the Escobar two-part test, which is this idea that the claim form itself actually has to say something about what was provided. In many cases, that may not be a controversial point. In other words, oftentimes, a healthcare provider will submit a claim for payment and it will say, service X was provided to patient Y on this date. So there's a statement about what has been provided. But not all claim forms submitted to government payers always contain a representation about what has been provided. And so this is kind of an important prong one of the Escobar test, and it's one that's important to evaluate to see whether it's been satisfied in your case, whether at the pleading stage. In other words, is there an allegation about an affirmative statement on the claim and the complaint? And then, as you proceed through discovery and summary judgment, has that been really backed up? So part one of the test is I think, becoming a little bit more focused upon now that people are sort of settling in with Escobar, if you will. And so this has come up in a number of different cases, sort of the question of whether it is really a two-part test, because Escobar set out this two-part test, but then there's some question around whether those two prongs that were on the previous slide are actually mandatory, and in particular, whether prong one is mandatory or whether that's just sort of an example of a time in which an implied certification claim can go forward. I don't think there's any question about whether prong two is mandatory. I mean, materiality frankly long been considered part of a False Claims Act claim, and then the Supreme Court really sort of injected it with a lot of vigor when it issued the decision a couple of years ago and put some definitions around what materiality means. But as to this part one, this affirmative misstatement on a claim form, that's a little bit different. So the Gilead case was a Ninth Circuit decision. It's back in 2017. In that case, the district court had dismissed the case, which was an implied certification case based on alleged violations of Food and Drug Administration regulations. The Supreme Court, so a petition for cert was filed in the Supreme Court following the Ninth Circuit's reversal of the district court's dismissal. The reason this case is, I'm jumping around because the reason this case is interesting is really on a number of levels. So the Ninth Circuit reversed the district court's dismissal, but in so doing, it held that the two-part test that we talked about on the previous slide was mandatory. In other words, there had to be an affirmative misstatement on the claim form in addition to materiality for the claim to go forward. So legally it held sort of, that both prongs were mandatory, but then it held that the plaintiff had effectively stated a claim. And so it reversed the district court's dismissal of the case. So the Gilead filed for cert. That's pending. The Supreme Court has asked for the Solicitor General's views on the issues implicated by the petition for cert. And that's kind of hanging out there. But the focus of the petition is not so much on this two-part test issue. The focus is really on, the adequacy of the allegations around materiality. And so that goes to the sort of prong 2 of the test. So the case is kind of like this jumble of Escobar and all of the things that Escobar represents. But I think what's most notable about Gilead is none of those things. What's most notable is that the Solicitor General in its amicus brief to the Supreme Court has said that, regardless of everything, basically, if this is remanded to the district court, we, the government, are going to exercise our right to move to dismiss the case, sort of, hearkening back to the Granston issues that Reed and Becky both touched on previously. And the government highlighted, sort of the public interest and the fact that if the case went forward in the trial court, there would be burdensome discovery requests to the government and TUI requests to the FDA, and it would just be a big burden. So this is, without really they took a position on sort of the legal issues and the typical kind of party line of, government says basically, everything's material. But they say that they're going to dismiss the case because they're worried about kind of the impact on resources and drain if it's back in the district court. So we'll just have to see what happens with this whole case and where it ends up. But it's interesting that it sort of implicates all of the Escobar issues, and now the government's coming out saying, if it proceeds, it's going to be dismissed. So we'll see. Following Gilead was a more recent decision this past fall in Rose. Let me move the slide. Rose versus Stevens Institute, and this was another two-part test case, and the Ninth Circuit panel in this case was extremely reluctant to say that the two-part test was mandatory, even though in Gilead, the panel in Gilead had said so. So what happened in Rose is that the Ninth Circuit was like, well, we're constrained by the prior Ninth Circuit panel in Gilead, so we have to say the two-part test is mandatory, but we think there's a question about whether this circuit would hold that the two-part test is mandatory if we were hearing the case en banc. So there was a signal there that there's some question about whether really part 1 of the test is in fact a critical piece of an implied certification claim. And, they cite a certain part of the Escobar Supreme Court decision to sort of throw some, shadow, if you will, some shade on that. But I've commented on this a lot, and this probably isn't the forum to be like, spouting off my views, but I wrote a blog post on this. I really think the better view here is that those two conditions are mandatory, and I've written on this a few times. But in any event, it doesn't look like the Ninth Circuit's going to resolve it anytime soon because they denied the petition for rehearing en banc in the Rose case. So in the Ninth Circuit, at least for now, those two steps to Escobar are indeed required. So that's been kind of an area of action under the FCA, and the district courts all over the country are also starting to touch on that test a bit more. I just moved ahead to, and I'm going to speed it up a little bit, but to the Sixth Circuit's decision last year in the Brookdale Senior Living case, which was a case about materiality, so part 2 of the Escobar test. And it involved basically the timing requirement as to when physicians can sign or validly sign, documentation approving the need for home health services. And in the Sixth Circuit decision, it was held that the relator had sufficiently alleged, so at the pleading stage is where we are in this case, materiality. And there were a bunch of factors that supported the Sixth Circuit's decision, or that the Sixth Circuit relied upon to support its decision, and one of which was this physician signature timing requirement was an express condition of payment. In other words, it was expressly articulated as a condition of payment by the payer. The number 2 is that the government did not have knowledge of the alleged noncompliance. And then 3 was that OIG guidance had specifically addressed the importance of the physician signature requirement. Of course, whenever I see the word importance, I cringe because Escobar isn't about importance. It's about materiality to payment decisions. So, things can be important in the in some sense that has no relationship to payment. But if it doesn't have a relationship to payment, then it's not material within the meaning of Escobar and the False Claims Act. So I sort of see that and I'm like, because that's not what, what it's really about. But, that's just, sort of shows how Escobar can be interpreted by different courts in a variety of different ways. So there's a cert petition pending on this, and we'll just have to see what happens. I mean, frankly, everybody's trying to petition to the court to get, clarity around Escobar, and, there's a lot of action in that field. So we're just going to have to watch kind of what the court decides to do, if anything, and it may very well be nothing, so we'll see. Going forward to Trinity, kind of on the other end of the spectrum, this was a reversal by the Fifth Circuit of a jury award of, nearly $700 million. And that decision stands because cert has been denied. But basically, this was a case in which the government basically was like, everything is fine. We agree that all of this is reimbursable. Everything was out in the open. The government even admitted it before trial. There's really no issue here, essentially saying there's no violation, or if there is, we know about it, we don't care, is the upshot. And so for whatever reason, the trial still went forward and the jury issued this whopping verdict. But the Fifth Circuit, I think rightly, on appeal, reversed that, finding that there could be no materiality in the circumstances. And then I think this is lastly the Rupp case. So this is a case that the 11th Circuit's going to hear oral argument on very soon. I don't know the date. But in any case, it's coming soon. And this was a case last, I believe, January that it came down of 2018. And it was sort of made waves when it did. It was the Middle District of Florida, again, overturning a jury verdict. But it's a very colorful decision on the issue of materiality, and sort of went through how, at least in the judge's view, no reasonable jury could have possibly found that the alleged violations at issue in the case were material to payment. So we'll see what happens in the 11th Circuit on this. I think it's a notable decision. It's definitely one to watch. I mean, these are all decisions to watch, and so many of them have either cert petitions or further review hanging out there. And it just goes to show that, Escobar has, first of all, led to sort of a whole different way of litigating False Claims Act cases, particularly in the implied certification realm. But, nothing is 100% settled, and things are being interpreted in different ways. So with that, I think my time is up, and unless there are questions, I'm going to hand it over to Amin, who's going to talk about the pain management industry and developments in that area.
Thanks, Laura. One of the issues we've covered over the last year has been the ratcheting up of the federal government's involvement and DOJ's involvement in various cases involving the pain management industry and some of the cases that have come out, mostly at the city, county, local government level, increasingly over the last several years. And it's really in the last year that we've seen a real uptick in federal enforcement activity in this space. And one of the cases that we've been watching very closely is the MDL litigation, the In re National Prescription Opiate litigation out of the Northern District of Ohio. And one of the things that we noted earlier in the year was that DOJ filed a statement of interest in the case and has been actively involved in monitoring the litigation, has been providing support around discovery with access to the Drug Enforcement Agency's database to obtain information. But the case is cutting across the entire pharma industry. It includes distributors, it includes pharmacies, it includes manufacturers. And as we've been monitoring that case, there were some significant developments at the end of 2018. In October of 2018, a magistrate judge in one of the bellwether cases in Ohio recommended that the case proceed to trial. And one of the notable decisions out of that recommendation was the inclusion of RICO claims under the Racketeer Influence and Corrupt Organizations Act, a recommendation from the magistrate that those RICO claims be included. In December, the district court judge approved the magistrate's report and recommendations, including the RICO claims moving forward, and essentially cleared that bellwether case to go to trial later this year. And the defendants there did appeal the decision seeking to exclude the RICO claims, but that request was denied just about 10 days ago on January 18th. And the commentary that's out there right now is really questioning whether the inclusion of the RICO claims impacts the ability for a settlement resolution early on in this very complex litigation. When DOJ filed their statement of interest, it really was viewed from our perspective as monitoring the case as it proceeded towards what appeared to be settlement discussions and the United States' interest in being involved in those settlement discussions. With the inclusion of RICO claims surviving motion to dismiss, it does raise the possibility that the plaintiffs are emboldened to take what could be significant penalties and criminal implications all the way up to trial. So we'll be watching that, and we'll continue to report back throughout the year. One of the other developments late in 2018 were comments from the Deputy Assistant Attorney General, James Burnham. They were delivered at the Food and Drug Law Institute conference in late 2018. And the Deputy Assistant Attorney General Burnham, he noted that, quote, the opioid epidemic is the deadliest drug crisis in our nation's history, and combating it is quite simply our number one priority. This was really the tail end of an entire year where everyone from former Attorney General Sessions to various officials out of DOJ, as well as directly from President Trump and the administration, emphasized the focus on combating the opioid crisis in the United States. Some of the points we've discussed in the past and were reiterated by Burnham at the FDLAS conference: the establishment of the Opioid Fraud and Abuse Detection Unit. This is a data analytics program designed to identify and prosecute individuals contributing to the opioid epidemic. A focus on criminally negligent doctors, pharmacies, and distributors, and the use of criminal and civil actions to combat that abuse. Number two, the direction for each U.S. Attorney's Office to designate an AUSA as an opioid coordinator. DOJ's initiative to ask courts to revoke the prescribing powers of doctors that are abusing that power. And he also reiterated the establishment of the Prescription Interdiction Litigation, or PIL, task force. And this is a coordination between federal, state, and local resources, a program that is designed to aggressively deploy criminal and civil enforcement tools to combat the opioid epidemic, with a particular focus on manufacturers and distributors. And looking to all enforcement tools from the False Claims Act to the Controlled Substances Act, and DOJ working very closely with Health and Human Services to investigate and to bring enforcement actions. One of the interesting things that Burnham mentioned during his speech is the utilization of risk evaluation and mitigation strategies to address the opioid crisis. Just as a high level, REMS are imposed by the Food and Drug Administration as a condition of improving certain drugs with safety concerns, including opioids. And what REMS can do is they can require certain medications with those serious safety concerns to help ensure that the benefit of the medication outweighs the risk. And REMS are designed to reinforce medication use behaviors and action that support the safe use of those medications. And so they typically impose physician education and reporting requirements that are designed to ensure that the benefits of certain drugs or biologics outweigh their risks. The consequences of violating REMS is that the covered drugs may become misbranded under the Food, Drug, and Cosmetic Act. And we have seen enforcement activity in the space around REMS, a $58 million settlement with Novo Nordisk, which was related to alleged failures to communicate accurate risk information about the potential risk to patients developing rare cancer, and a $35 million settlement with Agirion Pharmaceuticals, and also included a guilty plea there. So what the Deputy Assistant Attorney General articulated was that REMS would be used along with the various other enforcement tools as one additional mechanism to start to force certain behaviors, particularly in the opioid space. The conclusions coming out of his speech were pretty clear. Every participant at every stage in the opioid business is coming under the microscope. And he also strongly encouraged everyone in the manufacturing and supply chain to get ahead of DOJ's enforcement efforts and work with DOJ to correct past mistakes and stem the future death toll. So I think what we expect to see in 2019 is no slowing down of federal enforcement efforts in the pain management industry and really cutting across the entire industry. So looking to activities that may have occurred in the past and looking forward towards how you might change behavior and compliance will be critically important in 2019. I do want to note for folks that are in New York State at the conclusion of our program that the code for CLE is DOG28, D-O-G, all caps, 28. And I know we're slightly over time, but I think we will take one question and then we will wrap up. And I believe we have a question that is for you, Becky, from the audience. And the question is whether we are seeing fewer Yates file requests for individual records relating to investigatory subjects in light of some of the changes we've seen in Yates recently.
Yeah, I don't have a crystal ball into what the overall picture is at this moment, obviously, at DOJ. But I have not personally seen really a change, but I also would point out that the revision to the policy was just as of essentially, the beginning of December of last year. So it's only been in effect for about 7 weeks or so. And these kinds of policy changes take a while before you really see their impact, largely because the pipeline, is what it is, and investigative and charging and, prosecution and enforcement decisions have long been made. So this will really affect, we would expect to see more of an effect for newer cases or cases that have not already gone down a pretty unchangeable path. So probably more to report on that in the next, over the course of the next year.
Thanks, Becky. We want to be respectful of folks' time and wrap up, but we want to thank everyone for participating in this webinar. Again, you will receive an email with a survey, and we would greatly appreciate your feedback on the program. You'll also get a link to the fourth quarter report of the quarterly roundup, as well as a link to this audio webinar, which you should please feel free to share with your colleagues. Thank you again for your time and for joining us for the afternoon.